SJC-13475, Commonwealth v. James Bellard.
Okay, Attorney Osborne.
Good morning, Your Honors. My name is David Osborne. I represent the appellant, James Bellard, in this case. Mr. Bellard was convicted of witness intimidation under a bribery theory, which at the time was Chapter 268, Section 13(1)B.
You mean intimidation of a witness and the means being equivalent to bribery?
Correct, correct.
And I recognize that the ball keeps on moving on what the thing of value is.
Yes.
But having said that, could the defendant saying to the victim here, look, this is just how you can get back to normalcy, this is how you can get everything you want, ECF to leave you alone, police start knocking at the door, here's the plan, just do this. Could that be a thing of value?
No, I don't think that it could be, Your Honor. You haven't articulated in that scenario, which I think is the Commonwealth's position in this case. Yeah. I don't think it works even when you articulate it as well as you've done. It is, the problem with it is that there's several promises with it. First of all, there's no promise of a thing of value. It may be that Mr. Bellard, and this is, I'm saying this for argument's sake, it may be that Mr. Bellard didn't intend to interfere with his criminal prosecution by encouraging his fiancée not to cooperate with the authorities. That may be the case, but arguably. It's not my position, but that arguably is the case. The problem is you can't under Massachusetts law, be guilty of witness intimidation by this theory without more. There has to be an illegal means. And the illegal means in this case is the offer of a thing of value, the promise of a thing of value. Now, the Commonwealth says the thing of value is that Mr. Bellard, as you articulated, assured or promised his fiancée that everything would go back to normal and their lives would be as it was before the case happened. Now, there's a few problems with that, as I said. First, there's nothing in the record that supports the position that that's a promise of some sort. He did say, what the Commonwealth says is that position, that description is based on 4 facts. And I will point out, by the way, Your Honors, that the Commonwealth argued other facts at the appeals court, which it does not argue here. So I hope that means that the Commonwealth understands that those facts were not supported by the record. The Commonwealth said in the appeals court that...
Can I ask you what... Go ahead, I'm sorry. Can you just say what is a... Are you saying that what he said was not a thing of value for the witness?
Right.
It was not a thing of...
It's 2 things. It wasn't a promise.
Well, it was an offer, though, wasn't it? No?
It wasn't. He didn't make any offer. That's what I was going to talk about. But there is another problem, as you mentioned it, which is the thing of value. There's no evidence that this thing that the Commonwealth has described as the promise, even if it was a promise, and I do want to get to that, even if it was a promise, there's no evidence in the record that it had any value to the fiancé.
Does it have to be monetary value?
No, it does not need to be monetary value, Your Honor, but I think when something is not inherently valuable, if it's not cash, it's not a car or jewelry or something like that. If there's no inherent value to it.
Intrinsic versus extrinsic. So like if I'm a defendant on a case and Mr. Keneally, my cohort, is going to rat me out, and I call him and say, hey, I'll be your best friend for the next year.
Yeah.
If you drop the charges.
Yes. That potentially could be, and that would
be a thing of value.
That's correct.
As much as being my friend would, but that'd be a thing of value.
If he valued your friendship.
Right.
I won't pry into that, but that's something like the Ruano case where the court said in sort of an offhand comment that would have been, if the Commonwealth had brought a a bribery-type theory of the case.
It need not be, I'll take you to the Red Sox game, I'll buy you.
But there has to be some, but there has to, yes, but there has to be something in the record that gives you some confidence that that is something desired.
You don't think she wanted things
Yeah,
to get back to normal? Wasn't that her desire?
Yeah,
Wasn't that?
that's what that's what the Commonwealth says. But if you look at this record, and all we have, Your Honors, is this record. There's nothing else. There's no other evidence. There's no disputed facts. There's no.
Audio tape from the jail.
Pardon? Yes, it's
how
two
you know.
conversations, basically the same, but it's a 27-minute conversation. There's no dispute about what was said. And I encourage Your Honors to read this from start to finish, as you may have already done, because you need to understand the context of this conversation, which we can chat about in a moment if you want. But what she articulates throughout this conversation is, I want this harassment to stop. She never says, I want us to go back to the way we were. She never says, I miss you. I need you to help us take care of our children. There's not, it's quite striking, but there's not a single word.
But that's
that
presuming that the promise is that we're going to get back together. If you separate away from that, and I'm starting from a reverse order, that what you can hear is palpable is that she's tired of being deluged with, where are you, what are you going to do, prosecution, law enforcement, and therefore not necessarily that you're going to get back together, but I promise you that that anxiety and that angst and that frustration of people keep coming after you to participate will go away. How is that? I guess that's what I'm struggling with.
But it's the plain language of the statute. It requires the promise of a thing of value. And clearly,
But why isn't that a thing of value? You're saying monetary or otherwise. Why can't peace of mind be something that is incredibly valuable to someone?
it can be valuable, but he's not promising something of value to her. He's not promising her that the case the harassment is going to stop by something that he is able to give her in exchange for her non-cooperation. And that gets us to another question about whether or not there needs to be a quid pro quo, whether this needs to be an agreement or the offer of a bargain in which he will do this if she does that. That's
No, but
that's
would
a
you finish
separate issue.
whatever you were about to say? Why is this not a thing of value for her?
Yes, it wasn't a thing of value because she never articulates anywhere that she wants to go back to her life with Mr. Bellard.
But she
as
did
it was.
articulate the fact that she wants this harassment to stop.
Correct.
And he promises that this harassment
How
will
can that
stop.
be he can't promise something that he can't deliver.
Okay, so that's different, though.
The Commonwealth characterizes it as a
But
promise, but it's not.
he can have an understanding that in this prosecution, without her cooperation, the case goes away, and it does.
Well-
I mean, I don't know what other evidence they might have of it, but I mean, the way that it was split up, he was acquitted on part of it, and then the other part was this part, and without her cooperation, wouldn't the case be dismissed with warrant of prosecution?
And that has nothing to do with a promise of a thing of value to her. She never expresses, by the way, any view about how she wants the case to resolve. She doesn't say,
She does it, but I guess what I'm getting frustrated with is you're just not answering the question.
Well, I'm trying to.
If the prosecution and her participation in the prosecution is the part that everyone's coming to her to participate in, if the index prosecution goes away, no one's coming to her to participate.
Right.
So it's symbiotic. So if she's expressing frustration and all the other emotional feelings that she's feeling, and she wants that to go away,
Right.
and somebody tells her, if the index prosecution goes away by you not participating,
Right.
how is that not a promise related to a thing of value to her?
Because Mr. Bellard has no control over whether the case goes away. All he's doing, I've struggled, by the way, Your Honor, I know that the panel may be struggling with this as well. I have struggled with how to articulate the problem. When I first read this transcript, I said, where is the crime? Where is this bribe, this so-called bribe? I've struggled to articulate it. I've attempted it, and I know I'm falling short. But the reason that it's, I'll try again. The reason that this is not the promise of a thing of value is that Mr. Bellard is not saying, I will do this in exchange for something else. All he's doing is saying what He's telling her what the reality is, right? So if she doesn't, she says, I don't want to cooperate, I want nothing to do with this case, I want the police to leave me alone, I want the DA to leave me alone. And his response is, well, just keep doing that. Just ignore the police, don't answer the door. This case is going to be heard in a couple of weeks.
But you can
That's all
willfully
he
do it-
says.
You can willfully do it indirectly, and
You can do it indirectly, correct?
indirectly. And I know you want to get to the quid pro quo. That's actually probably a harder argument for you than whether or not this is a thing.
I'm happy to stay with this part of the argument.
Yeah, it's an easier, a less difficult argument for you, so I sort of would like to linger on this for another
I'm happy to do that.
moment. So you can do it indirectly,
Yeah.
and I know she says DSS, but, you know,
Yeah.
for a parent, the biggest thing is your kids. And
Yeah.
She's clearly distressed about.
Absolutely.
About DCF. And
Absolutely.
clearly having DCF not show up anymore, or not the threat of DCF, or not the police throwing the DCF thing around if they were, that would be subjectively a thing of value to her.
Absolutely. That was driving her. And what the Commonwealth said in the appeals court is, well, he promised her that he would help with the DCF matter. And of course, he never did that. And there's a reason for that. He had no ability to control what happened with the DCF case. All he said was, in this transcript, is, don't worry about it. They're just making a lot of noise. They're just trying to intimidate you. These are just words. These are attempts to persuade. They are not the offer of a thing of value that I will give you in exchange for your not cooperating.
Be a crime in federal court.
It could, depending on how they brought it. And yes,
Corruptly persuaded.
corrupt persuasion, yes. I think, and that's the problem here. I think everybody assumes that there's if somebody says something to encourage another person not to testify, that may be a crime that the legislature should address. But it is not currently a crime under Massachusetts law. Something like that is a crime under federal law, and could this potentially, I don't think Mr. Bellard could have been prosecuted under federal law, but there's at least an argument there. Because if you say...
Not to take you too much off your script, wouldn't we have all sorts of First Amendment speech problems with a law that says, stop talking to the police? Is a witness intimidation charge?
I think that's a good point, Your Honor. I think the federal statute says corruptly, so I think that might be how they get around that.
Right. I think that you must have to read something
Yeah.
into that corruptly.
You'd have to, yes. There's a split in the circuits about what exactly corruptly means. But
So saying to the witness, potential witness, be a stand-up guy.
yeah.
That would,
No, yeah,
that-
exactly, Your
that's
Honor.
not a crime.
If you just say, hey, don't testify, this is all going to go away in a couple of weeks, which is exactly what Mr. Bellard did in this case, repeatedly, over and over and over again. That's not a crime unless he's holding out something that's, because remember, what the legislature is trying to do, and the Commonwealth agrees with this, the intent of this is to prevent undue influence on a witness by intimidating them, or by harassing them, or by making misrepresentations to them, or by bribing them, or however you want to describe this particular prong of the statute. There has this very specific means. It's not just that you're encouraging somebody. The legislature could have said that, and there might be First Amendment issues with that, but they didn't do that. So you have to fit Mr. Bellard's conduct into this into this statute, and there is a huge hole here, which is that you don't have a thing of value. That even though there's something of value to her, clearly,
Isn't that,
but it's not something that he can promise her, because it is. But
doesn't he make it appear to be that he could promise it?
No, I don't
He's
think he
basically
did, Your
saying,
Honor.
If you ignore them, then
Yeah.
this is what's going to happen. He's advising her, I guess. You
But
would say.
remember, she was already doing this. She had told Mr. Bellard.
He says, don't answer the phone, don't answer the
Yeah, he said, and the reason is because she says, they're harassing me. And she makes it very clear during this conversation, she's not cooperating. She wants nothing to do with this case. She wants it to be done. And she doesn't want the police coming to her door. She doesn't want the DA coming to her door. And so he says, well, don't answer the door. Now, there's nothing more clever about his advice than that. It's just, keep doing what you're doing. My case is coming up in 2 weeks.
Well, isn't there a concern that she might change her mind? You make a big deal in the brief that there's nothing to do willfully
Right.
to get her to not testify. There's no need for a quid pro quo because she's not going anywhere near the witness stand.
Yeah.
Well, we
Well,
sort
that's-
of all know that it's not really the last 2 weeks out that matters. It's
Yeah.
usually, a day out or even a minute out that matters.
And that's true, Your Honor, and the Commonwealth says that in its brief. The problem is that, I'm not arguing that that's the only evidence that this is not a promise of a thing of value. I'm just saying that when you look at this conversation in its whole, in its entirety, and not these little snippets that the Commonwealth plucks out and says, well, he said he cared about his family. Oh, my goodness, can you imagine a man says that he cares about his family? That's a bribe. Or that he says that they're still getting married. Well, he said that before this conversation about the criminal case ever came up. And that wasn't a promise of marriage, as the Commonwealth concedes. It was just,
This is a light most favorable, right?
it is like most favorable, but there still has to be evidence beyond a reasonable doubt, even with taking the inferences in the light most favorable to the Commonwealth. So the Commonwealth packages up this promise, and sure, we can speculate and say, well, maybe he's going to confront a fiancé who wants to testify, although there's nothing in this record that would give you any reason to be concerned. She's making it crystal clear she does not want to have anything to do with this case.
Promise to be with her?
No, what he says is, you wouldn't be going through this is the quote, you wouldn't be going through the shit if I was out there. That's the quote. He doesn't say he's going to come back and stand by her, even if we believe that that was something she wanted. And by the way, this is a domestic abuse case. Maybe it's not something she wants.
Well, why would he be talking to her?
Well,
Right, so
she
kind of begs the question.
we can speculate, but that's the problem with this case, Your Honor. That's the problem. All we have is speculation and conjecture. We don't, because all we're limited to is this. I think we know what happened here. The Commonwealth knew it wasn't going to have a witness in this case. And so it went through all of his transcripts.
Of course they did.
And they found this. And by the way, Your Honor, this is the best they came up with. This is the best they came up with. And if you want if you want to understand any reason to doubt that there might be a reasonable doubt here, beyond a reasonable doubt standard met here, you just have to look at all of the variations on what this thing was that.
Did he at one point say, something along the lines of, just do what's best for you or something?
He did say that, which I think it goes to my point, which it confuses this whole motive question. What's his motive? Is his motive because he's trying to deal with an upset fiancé and he's just trying to calm her down?
I know you don't think the motive's clear. I think the motive's clear. I just don't know if it's really a crime. The motive is that he's trying to placate her. He's trying to get her into his camp. He's trying to say, just keep on doing what you're doing. He's trying to get to the trial date so she doesn't go in and testify.
Yeah.
And he's playing her. It's not too complicated to see what he's doing. The issue is whether that constitutes a crime.
And also whether you've proven that element, the intent element, beyond a reasonable doubt. And I think that's my greatest problem with this case is that you can make the argument, you can strain, as the Commonwealth clearly did here, and present a set of facts that, the trial judge didn't see it the same way as the prosecutor, the appeals court didn't see it the same way as the trial judge. I mean, everybody's come up with a different concoction for what the bad conduct was here. But we're straining to make a crime here when maybe it just wasn't. Maybe it just isn't there. He was encouraging, as Your Honor says. he certainly had a motive to not have her testify. That's unquestionable.
Okay,
And-
I'm sorry. We're almost 5 minutes over, and
I'm sorry, Your
you
Honor.
have absolutely made your points. Thank you so
Okay.
much.
Thank you, Your Honors. I appreciate it.
All righty. Okay, Attorney Zhang.
Good morning. May it please the court. Kristen Jang for the Commonwealth. I believe the biggest issue here is whether or not there was a promise made in this case based on the transcripts that's before the court. And it's the Commonwealth's position that there was an indirect promise made here.
What's the promise?
That the defendant and this witness would resume their life as it was before if she listened to him. If she listened to him, she stopped answering the door.
Where is that in the transcript?
So it's implied. It's not directly in the transcript. There's no direct quote.
The transcript are you relying on?
The strongest pieces, number one, on page 19, you wouldn't be going through this if I was out there with you. That's probably the strongest line that I can pull from the transcript. There's also sprinkled throughout the transcript in the context of, we're still getting married, I care about her family, and listen to me, and this will go away. He says that over and over again. Listen to the man that knows. Listen to me, and this will go away. As to the DCF case in particular, it's true that he didn't say that he was going to help her with the DCF case. I don't, and I apologize if my argument to the lower court was misconstrued. He said that the DCF can stay open till whenever. It doesn't really matter. Meaning, if you listen to me and you don't show up to this trial and testify against me, you don't have to worry about it.
Is that something in his control?
No, it's not. I agree. That's not in his control. It is in his control to some extent. The defense strategy, he knows very well from his lawyer that if this witness doesn't show up, that the case is going to go away. And he communicates that to her.
Why isn't this just stating the fact? Why isn't this just trying to, make her feel better about things? Why isn't this just advice? Why isn't this just trying to persuade her?
Well, his intent really comes through the transcript when he says over and over, listen to me, listen to me, listen to a man that knows.
And the intent is that she not testify, right?
Yes,
Okay, so we can agree on that.
yes.
But why is this not just, here's what will happen. If you don't answer the door, they'll stop coming. If you don't say anything, everything will be okay. He's just telling her what the fact is.
Well, read in the context of their relationship, that's coming through the transcript, where he says, I care about you and our family, we're still getting married, right? When he talks about, you wouldn't be going through this if I were
agree.
out.
No, I agree that he said all of those things.
Yes.
Yes. So why isn't this just him telling her the fact of the matter?
Because those statements pull it out of just him giving advice, especially read in light of their history of domestic violence. I know we don't have explicit facts on the record here about their history, but we do have facts that there was an assault here that left her bleeding from the mouth and she was taken away by ambulance, and that's the case we're talking about here.
Was that in the trial record
Yes.
for this trial?
Yes, the docket, and then there was testimony as well about, because really the issue at trial was whether or not he was the one that made these calls, but there was the arresting officer did testify at this trial, so that is in the record.
Counsel, can you just remind me, is this was this a separate docket number from the underlying domestic case?
Yes, it was.
In this particular docket, was there a stay away, no contact order?
I don't recall from the record. I
Is the docket
apologize.
on this case in the record appendix?
It should be, yes.
Okay. Would that inform at all the analysis here? If there were a stay away, no contact from the alleged victim and to kind of give the flavor to what this really was?
It would inform it more if this were an intimidation case. I suppose it could give some background to, I think it makes a difference that this was a DV case. That was the underlying case. This wasn't a theft or something like that. This was a domestic violence case. I think that does give flavor to this.
So, before I ask you whether or not what was being offered was within the defendant's controlled promise, I just have a technical question. that's not addressed in the brief. When, as you know, when you have a jury waived case, this is jury waived in front of Judge Flatley.
Correct.
When you have a jury waived case, the judge doesn't have to say anything.
Right.
But the judge does say something, and if I'm remembering correctly, she says, well, there was a promise. And the promise was that if she didn't testify, they'd get married. Is there anything binding since she said that, about that being what's required for the Commonwealth to be able to show sufficiency?
I don't believe there is. I did do a little research into this. There's not a lot on it. But, well, for one, in the record, she said, based on what I just heard and that explicit offer of marriage. So she was referring to what I just heard, which was a portion of the recording that the prosecutor had played during her closing. So I think that that covers us here because she was referring to the same transcript that we're all looking at here. So I think it's fair game for me to point to any part of the transcript. But also, you know, if this were a jury trial, we wouldn't really know the reason that they found this defendant guilty.
I'm sorry, yeah.
Right.
But if she said that's the reason that I'm ruling that he's guilty of this,
Right.
and that's not, are you arguing that that was the promise?
No, the offer of marriage, no, absolutely not. I concede that there's no support
We have to
for
look
that.
somewhere else.
Correct. Yeah, I'm just proposing that you can look somewhere else. You don't have to rely on that
Have to
incorrect
look-
finding.
Yeah, we have to look somewhere else.
Correct. Did I answer your question completely? I'm sorry.
Yeah,
Okay,
except
thank
we
you.
don't have an answer. If you don't have to do anything, the judge doesn't have to do anything.
Correct.
If the judge said, my theory in this jury waived case is theory A, and there's not enough evidence of theory A, all right, and there is of theory B, it's too bad. She decided to say theory A. She didn't have to. It's jury waived. In jury waived, you say guilty or not guilty.
Right.
But anything you say is fair game. So I'm not sure we have an answer to that question. But here's what I see as the biggest challenge. Not whether he was trying to influence her, because he clearly was trying to influence her. The issue is, can you have a promise under the statute of something that you can't control?
Well, an analogy would be, what if he did say, will you marry me? I'm going to marry you if I get out of here, but she doesn't want to marry him. I still think it's a crime when he finishes that sentence.
Because he can control whether.
That's true. He could control his end of it, but he can't control the result. He can't control whether she's going to say yes or not.
Well, that's the same as if I said, I'm going to offer you $500 and you're not going to take it. It's still.
Right, or you don't have the money. Maybe you don't have the money. But I think that still completes the crime when you make the statement. If you think that.
Control. You know whether you can marry someone or have $500.
Right.
What you don't know is whether or not you can stop the police from coming, get DCF to leave you alone, get back to whatever that normalcy she's looking for is. It's not something that he can unilaterally do. Does that matter?
I think here, to distinguish it a little bit, he does relay his lawyer's advice that if she doesn't show up, it's going to all go away and be fine. So that's a little bit of a distinction here, is that he's purporting this professional knowledge from his attorney that as long as she doesn't show up, this is going to be fine.
But that doesn't answer the question yet.
Conditional.
Yes, that's true. That's true.
And he doesn't have control over it. I mean,
He doesn't.
Right.
He doesn't. He does have control over this general sense of resuming their life as it was before, which is without police coming to her door, which is without the prosecutor's office calling her, et cetera. If there are no further questions, I'm happy to rest on my brief.